content data. What are these forms? Other than the content, origin, destination, route, time, date, size, duration, or type of underlying service. People will say you still need a warrant for traffic data. Conventions, laws, other countries, nobody requires a warrant for traffic data. Content data, the Supreme Court, Department of Justice, all the way down to our field offices, we will never touch content data without a court order. That is administratively liable, criminally liable, civilly liable on the part of law enforcement. Remind us, bring us to court, we will charge them. Report it to me if the NBI or NBNP is the first to open content without a court order. We're very clear on that. That's a line we do not cross. Okay? But on the traffic data, it's a different matter. Let me illustrate that. Traffic data is literally traffic along EDSA. It's not something that you not see, something that you experience every day. And if you don't notice, here, we already have CCTVs anywhere. In fact, as I speak here, there will already be CCTVs. When you move through the land bank building all the way here, public spaces, we are already monitored. For what? It's a public space, there is no claim to privacy. Okay? Now, when we spot a bus here, there's a plate number, or if the plate number is not there, if it's a fake plate number, what happens? You can record that. It's public space, it's public domain, especially if it's a kidnapping in progress or a terrorism target moving to the bomb destination. Nobody questions why this traffic data is being collected. Similarly, and this is the nearest parallelism, if you migrate traffic data literally to the online world, how many emails are being sent? You don't know who, you don't know what the content of this email, subject to some technical niceties, but the basic idea remains. Traffic data should not require a court warrant. Simply because, given our slow justice system, by the time you get a warrant, which is a couple of weeks, the data is gone. It's very volatile, it's very, very ephemeral. And the Supreme Court has said ephemeral electronic communication is an acceptable form of evidence. So that is the position, but of course we will have safeguards along the way, we will illustrate in the last part of the slide. Similarly, this is our post office. When you register or when you log in, when you register or you send a post office, you would say sender's name, how much is the postage, from Manila to Tawi-Tawi, from Manila to Hong Kong. Those are not private. There is no stifling of the right to privacy. Those are objective data that's verifiable, that is not infringed on your right to privacy based on content data. Okay? That is the framework approach. You can read up on that. Now, everyone's favorite part, Section 19. Let me clarify this. Since last week's interview, we have said, do not use the word takedown liberally. Talk to your technical friends. Maybe Lito and Abed from PhCert can discuss this clearly. Takedown, restricting, blocking are two different entities. Very, very separate. Takedown requires a whole team of forensic people going to the telcos and literally, physically taking down that particular data. That's almost impossible to do. Restricting, blocking, we will discuss that in the next slide. But the basic framework is, it's not the takedown provision. Everyone says take down, take down. Even the Supreme Court says take down, take down. But we need to exercise rigor because this is one slide that has a technical dimension because of the nature of cybercrime. Okay? So far, let's leave it at that because the easiest way to understand Section 19, I'll give you a very quick tip just because here, you just have to move it 3 sections up. Instead of Section 19, put it after Section 15, which is in the original formulation. Because after adding it all in, from Section 15, went down to 16, went down to 17, went down to 18. Now it's Section 19, and you read it, it seems very arbitrary, out of place. But the whole idea is not. In the IRR, we hope to rearrange some of the provisions. Section 19 now, at least, will come after Section 15, protecting the law, no change, but making sense of how it works. The original formulation talks about central authority, not the DOJ, although there's a certain equivalency that I will explain in the last slide. This Section 19 restricting, blocking provision, we have already initial discussions because, as we said, our TWG version was cut up. We have to make some analysis. And When does this apply? I got this question many times last week. It will apply in very restricted cases. The case should be transcendent. There should be time-critical element. It's not going to be just for any website that's there. The clear and present danger rule has to be met, that there's a reason for us to work towards restricting or blocking it. Commission of patently illegal acts. Live streaming of a child being raped, possibly. And if you look at this, the Luneta incident, remember the infamous Luneta incident, if it disrupted the rescue and the safety of all the massacre victims, and somebody was actually live streaming all the data, perhaps in that circumstance, we would say, restrict, don't do it yet, because lives are at stake. Very, very restrictive, very, very close application of that. How to make IEDs? I don't know how you feel about this. If you think it's free speech, free information, that's fine. But in certain countries, how to make a bomb, how to assemble the electronic detonation, those sites you can access. Keyword blocking. But we will not discuss that. It's going to take a different narrative. Another situation is creating panic or fear. Let's say after this site, the website says, all participants of the 2012 Cybercrime Forum contracted AIDS in the Land Bank Plaza 10th floor. Now it's being it's creating panic. Everywhere you go, everyone says, stop. We don't want to deal with you. You just came from the Cybercrime Forum. Would that be a ground? A school infected with SARS-like virus? That's not true. Those are the specific circumstances that Section 19 could possibly be invoked. Creating panic and fear. Terrorism. A live going on stream and says XYZ. We are going to bomb this. Extortion, kidnapping. We have to discuss the contours of this yet. Because as I said, the law has been arranged a bit. We need to rearrange it in the IRR to make sense of it. Mass suicide. At 6 o'clock, October 9, we will have a common pact. Let's all bleed to death against the Cybercrime Prevention Act. I don't know. For you to talk about. Up. Quarantine. Sometimes the Department of Health says, wait, this house, nobody goes out yet. Nobody comes into the country yet. You've been suspected of flu-like syndrome. Hold till you prove you're okay. Or till we check the symptoms are okay. There's some shifting of the burden, but not totally unacceptable. Public health issue. Warrantless arrests. We're very familiar with warrantless arrests. There are very clear exceptions, about 7 to 10, in our statute books that says, even without a court order, you can be arrested. And this one is the arrest of a person, a live body. In Section 19, we're talking about inanimate objects, a website, a page that calls for terror, a page that calls for mass suicide. That is a different paradigm. There is no immediate threat to life or liberty. And I was hoping that we would also have a very strong vigilant type of monitoring for checkpoint search. We see a lot of abuses in our checkpoints. No warrants required. You're driving, you're stopped, you're searched. That is a bigger danger because at that point of engagement, at midnight, you're driving alone. Perhaps you could be a lady driver or a young adult. That is where the real abuses will come in because of the immediacy of the search or the arrest. At present, the Department of Justice already does HDOs, watch lists. We also already arrest people. This is what we talk about the awesome powers. There's nothing more awesome than investigating you for a crime, arresting, NBI arresting you, or deporting aliens, or stopping aliens from entering the countries who are Yakuza members or triad members. There's nothing more powerful than those acts. Restricting, blocking access in the hierarchy of powers the government has, very low. It's not something that it's painted as awesome powers to do this. It's not. In the hierarchy of rights, I've always said this, we'd rather have a department that's used to how manage levers of power, how to take care of the abuses, how to entrap people. You would want to give certain powers to that rather than just giving it to anyone who is not used to the notion of power and the responsible exercise of power. Wait until you're indicted for a criminal charge for murder, for estafa, for fraud. that is where you will feel the power. Not restricting